So with all this, the important message is that the life of the IP becomes tough because you thought you'll be able to get over this entire process by one year or a couple of years, but then the process continues to move on, drag on, and that's not healthy for anyone's career. And therefore, a lot of people are wanting to, a lot of people actually have left, a lot of people are wanting to leave. I don't think that's a very healthy thing because, and that's why I was asking if somebody from IBB also was there. Possibly, it might also be important to engage with IPs and look and hear them. They are the warriors. The entire battle of non-performing assets and default corporate defaults, the warriors who are going to fight this battle are the IP. Therefore, hear them, give them a sympathetic, empathetic ear, hear from them what are the issues they're facing, and that's very because ultimately you strengthen the insolvency resolution process only when you strengthen the insolvency professionals. Like Ram wouldn't have won a war unless he had a strong army. Having a strong army is the prerequisite for any, and the best of warriors or the best of the kings will still need a strong army to fight. So the battle of insolvency wouldn't be fought or wouldn't be fought effectively unless we had a strong army of IPs. Therefore, do hear out what the IPs have to say. It's been 6 years of their experience now. So do hear them out, listen to what their problem, give them a empathetic ear, listen to them. So this was the first change I want to talk about. Let me now move to the next important change. And I'll now,
Vinodji, if I can
yes,
ask one question.
yes,
So
please.
this was regarding the resignation in all situations, but apparently this situation for voluntary liquidation process has not been dealt with. So you have some views on this, please?
Anilji, the answer for that is very simple. Voluntary liquidation is purely contract between the company and the liquidator. Because that's a very simple contract. The company appoints the liquidator. The resolution is passed by the company in general meeting. So that's completely between the company and the liquidator. And therefore, at the time of passing the resolution itself, the liquidator could have kept a possibility that I will be able to resign. But the question there is resign to who? Because the board of directors have gone away. You are now the sole person looking after the company. Therefore, you should have actually kept a provision while passing resolution that in case for whatever reasons there is a need for the liquidator to resign, then there might be a committee of the former directors or committee of stakeholders. I would rather say committee of stakeholders because the contributors in that case become important. So the contributors may have a committee of 2, 3, 4 people whose concurrence may be taken should the liquidator in case of voluntary liquidation want to resign. I think IBBA did not possibly want to make this change or wanted IBBA probably did not feel the necessity of making this change in voluntary liquidation because that's purely between the company and the liquidator. Unlike situations of insolvency where there is a body of credit, there's no involvement of creditors here. In voluntary liquidation, I'm sure you understand there's no involvement of creditors at all. Creditors are not at all affected because we're paying everyone, we're paying them out. So there is no relevance of creditors here, and therefore there is no COC or stakeholders consultation committee kind of approval. You can have the stakeholders, one or two representative of stakeholders, normally the holding company or the major shareholders, and their concurrence should be sufficient to take care of any situation of replacement or resignation.
So are you suggesting that let there be some resolution in terms of your suggestion that yes, in case the need arises for the resignation, so let this be put up to contributories or stakeholder, because neither there is a SCC nor a COC, any such bodies there.
Absolutely. There is no COC, there's no SC. There cannot be a COC at all because you're actually paying off
Correct,
everyone.
correct.
Neither can, there is no, the only stakeholder in voluntary liquidation are the shareholders.
Contributories.
The contributors are shareholders basically, right?
Yeah, yeah,
Contributors basically. They're the
yeah.
recipients of the cash flow. So I would suggest when we pass the resolution for commencement of voluntary liquidation, there we should
Yeah.
also keep a provision for having 1 or 2 or 3 representatives of the major contributors. Normally, it would be limited number of. It wouldn't be like
Yeah,
10,000 shareholders there. It would
yeah,
probably
yeah,
be a number
yeah,
of shareholders.
yeah.
So get some representatives of the contributors to agree to certain matters because sometimes there might be need to make modifications also. I mean, they might be need to take concurrence. For example, I'm going to incur an expense. Let's say I'm going to incur an expense. Let's say I'm going to file some litigation against some debtor. Should I do it or should I not do it? Who do we ask? Unlike in case of insolvency situations where you got a COC or SCC to go to, there is no go-to person in case of voluntary liquidation. So I would normally suggest that at the time of passing resolution itself, one can keep a process, one can keep names of 2-3 people to whom we may consult or whose consultation we can rely on should a need arise, and there this might also serve as the body to whom a resignation, if need be, might be tendered, or they might also likewise be a process for replacement also. If they are not happy, I'm doing work but the stakeholders are not happy, they can also remove me. So it could be both ways. So that's how it should work in case of voluntary liquidation.
Thank you. Thank you very much.
Deepa, you mentioned something, but would you like to? I'm not. There's this NDA which is to be signed before starting this. What NDA are you talking about? Non-disclosure agreement for what? I couldn't get the NDA thing, Deepaji. NDA is typically in case of consulting assignments. Not. I'm not sure how would NDA be relevant here, but should you have any question or point to make, please do unmute yourself and say that. Uh, if not, in that case, we will continue to move on. So we were talking about other important changes. Let me straight come to. Right. So we were talking about the significant changes, and here we are. So we'll be discussing the liquidation process amendments in liquidation process regulations, and then we'll talk about CRP changes. Let me first get started with the changes in liquidation process regulations. Now, one of the important or the bunch of changes, major changes in liquidation process regulations relates to having more consultations, in many cases mandatory consultations, with the so-called stakeholders consultation committee. This has got a little history behind it, and I think over a period of time, the regulations about stakeholders consultation, particularly liquidation, have continued to evolve, and the situation has now taken a complete turn from what it was when insolvency bankruptcy code began to where it is now. Let me just talk about this trajectory of major change, because when the code was first implemented, the thinking that all of us had, and this was thinking at IBBA level also, that the scheme of the law is very clear. The creditors are in control during CRP. During CRP, the RP or the IRP is simply a masters of ceremony. He's simply a conductor of the entire process. The process is under control of creditors because all decisions are taken by committee of creditors. So that the situation is like this: when the company is not insolvent, solvent company, under whose control the company is. If the company is solvent, it's meeting its obligations on time, it's paying its creditors on time, the company is under control of the directors. The directors, shareholders control the company. Shareholders have indirect control, directors have direct control, but everything is under control of the directors and shareholders as long as they're paying the creditors. Once they default to creditors, the directors are removed and the creditors take over. Creditors take over the control, so the company comes under control of the creditors during CRP. But CRP is the last of the opportunities for the creditors to retain control of the company, such that if the creditors are not able to find a resolution, not able to agree to a resolution during the CRP process, then they are also able to see that henceforth, the moment liquidation commences, the company will move out of their control and go into the hands of a professional. So situation was, the control is with the board of directors and shareholders during solvency. It goes to creditors in the stage of insolvency. And during liquidation, the entire control shifts to a professional. The question of any decision making on the part of creditors would not be intuitively matching with the idea of liquidation, because liquidation basically is what? Liquidation is terminal process. We have come to a realization that the company cannot be resolved anymore. Resolution has failed, which means the liquidator is now having the task of disposing of the assets either on going concern basis or on piecemeal sale basis, realize the money and pay off the creditors. There is nothing for the creditors to do here by way of decision making. All decisions are therefore under the control of the liquidator. And this is what was coming from the code itself. The code itself had this provision, explicit provision, that the liquidator may consult, liquidator may consult, the liquidator may consult any of the stakeholders, but at the same time it said liquidator may consult, however, the consultation shall not be binding on the liquidator. Therefore, number one, the consultation was at the volition and the discretion of the liquidator, part one. Part two, even if the liquidator wanted to consult and the consultation was, let's say, going into a particular direction, the liquidator could actually take a different decision. He wouldn't be bound to follow the recommendations of the stakeholders. This was the position with which we started. There was no concept of stakeholders consultation committee. I must remind that during the 56 Act also, in the winding up provisions of the Companies Act, there used to be an advisory committee. The liquidator could have an advisory committee. The liquidator could take advice, but the decisions of the advisory committee were never binding on the liquidator, because liquidator used to be a court appointed. In the old process, it was court appointed professional. In the present process, while the liquidator was appointed, so to say, by the committee, because normally the RP itself continues to be liquidator, but the last chance of the creditors having control on the process was still the CRP, post which the control will shift to the liquidator. And given the fact that it was indecision, so to say, indecision or unsatisfactory decision of the COC, which led the commencement of liquidation. I hope I'm trying to make my point that it was indecision on the part of creditors which ultimately made the entity to move into liquidation. So if you're still depending on decision of the creditors during liquidation as well, what am I trying to arrive at? Depending on decision making of a body which had the time to decide during CRP and was not able to decide, because they had an opportunity and probably the last opportunity to decide and resolve during CRP, which didn't happen for whatever reason. So to an extent, it was nothing but indecision. And if indecision was the root cause of liquidation, in liquidation itself, we're depending on decision of the stakeholders, it sounds little counterintuitive. I'm reminded of a Urdu ka sher, and I hope I can say that. बोल देता हूँ कि जिंदगी से ऊब गए तो मर जाएंगे, जिंदगी से ऊब गए तो मर जाएंगे, मरने से भी चैन न मिला तो किधर जाएंगे. How does it relate to the situation? Indecision cause liquidation. In liquidation also, we depend on decision of the creditors. What are we trying to attain? Anyways, that was, I would say, that was the thought process with which in 2019 the concept of SCC came. And from 2019 till 2022, the SCC composition itself has changed. I think earlier it was all representatives, including promoters. Then it was class of creditors in 2022. So the composition itself has been undergoing changes as the concept of SCC has evolved. From 2019 until now, I think it's actually more than 3 years of existence of SCCs. And I'm not sure, you all are practitioners, you could probably brief me on that. I'm not sure how effective have the SCCs been in assisting the liquidator to take fast decisions. The whole idea of any consultation during liquidation is what? Liquidator is anyways going to sell the asset. Liquidator cannot take whimsical or arbitrary decision, because after all, he's working under the supervision of the NCLT. And any of the actions of the liquidator anyway are challengeable. But the question of the SCC being there basically is what? The SCC could assist the liquidator where the liquidator needs decision, where the liquidator needs support. So have SCCs really been able to support the liquidator? Have the existence of SCCs been able to reduce litigation? Because otherwise, anything that the liquidator does would have probably been challenged by creditors. So has the tendency of the creditors to challenge the action of the liquidator, has that been taken care of with the 3 years or over 3 years experience of the SCCs? So my two questions are, and I'm hoping that some of you could probably contribute here vocally as well, because what we now see is that the scope of powers of the SCCs has been significantly increased. Lot more powers, and actually making it mandatory now. Earlier it was you may consult. In fact, law, the IBC continues to say you may consult. See, the little conflict between the code and the regulations now is that IBC continues to say liquidator may consult, and the regulations now say liquidator shall consult. So it's actually gone loggerheads with the law itself. But that's it. I mean, I think don't think we need to be discussing here the conflicts between the regulations and the law. So my question, before we come to what significant changes there are, if any of you got experience to share, have SCCs been effective in terms of helping the liquidator to move fast, and has the scope for litigation been reduced because matters were done after consultation with the stakeholders consultation committee? If any of you have experience, please do share. If any of you would like to speak, you can raise your hand. I would then request the host to unmute you to allow you to speak, unless you can unmute yourself. Do any of you have any experience to share? Are the SCC so far? I mean, I'm guessing, I'm sure many of you are actually acting as liquidators anyway. I can see some questions have come up pertaining to SCCs. There's a question by Mr. Satyanarayan Veer Venkat Chebrulu. Before we come to the question, would any of you would like to speak on your experience of dealing with SCCs? If you want to share experience, kindly raise hand. Otherwise, we will just proceed further. And I'll come to the question which has come on the chat, but in the meantime, let me just say the changes. Very significant changes. In fact, a lot of changes now as far as SCCs are concerned. Enhancement in the role of SCC, because now you are asking for several matters where mandatory consultation will be required. Not only that, it's now talking about monthly meetings of the SCC. In fact, what was COC during CRP is now virtually becoming SCC in a little expanded sense, because COCs in CRP mostly consist of financial creditors only. But when it comes to SCCs, it not only consists of financial creditors, it has other stakeholders, namely the operational creditors, the government departments, the workers as well. So it's COC in a little more expanded sense. And like there is a provision in CRP, which is now talking about monthly meetings of the COCs, there's a similar provision in liquidation regulations as well, talking about monthly meetings of SCC as well. Every month you need to call the SCC meeting and therefore do a consultation with the stakeholders every month. In case of COCs, permits the COC to extend the tenure, therefore not make it monthly, but maybe make it quarterly. I'm guessing similar provision is there in case of SCCs as well. There are some provisions which are quite helpful. Number one, the proposal for compromise and arrangement can be filed only within 30 days of liquidation commencement date. Compromise arrangement during liquidation is a very contentious topic, and we have recommended that this provision about compromise settlement during liquidation should be taken off, should be taken away completely as far as insolvency liquidation is concerned. The provision may remain for other liquidation, but as far as IBC liquidation is concerned, the provision should have been taken away altogether, because this is actually being misused, and people are normally aware that this has been so far greatly misused. This could actually be removed altogether, but since IBBI couldn't have made a statutory amendment, they have narrowed down the window of time only within 30 days. 30 days of liquidation commencement date, you can move a proposal for compromise arrangement. Beyond 30 days, a proposal for compromise settlement cannot be filed at all. Compromise settlement, I'm sure you are aware, comes in a section 230 of the Companies Act. And if at all compromise settlement is proposed, then the matter will go to NCLT, not AA, now NCLT. And if at all the compromise settlement is voted upon and is approved, then the company will come out of liquidation. But that is something which is now possible only within 30 days. I was talking about increasing role of SCCs. So as you can see, very importantly, disclosure of the valuation methodology will be done to SCC. Regulation 35/5. The valuation methodology will be placed before the SCC. valuation report will also be placed before the SCC. Now, I must say that in the past as well, where SCCs were not there, it was very commonplace for us to share the valuation reports, because names of valuers or valuation approaches or valuation reports were typically shared with the creditors. But important now that SCC consists of other classes. Please understand that when it comes to SCC, the divergent classes, interest of different classes of stakeholders in the SCC is actually divergent. It's actually not just different, divergent, mutually conflicting. Because what is in the interest of secured creditors may not be in the interest of workmen. What is in the interest of workmen may not be interested in government departments. What is in the interest of government department may not be in the interest of operational creditors. Each of these stakeholders have diverse interests. Another very important feature is that the promoters, the representatives of shareholders, they are also there in the SCC. They are not entitled to vote, but they are still there in the SCC. So that creates a very difficult situation, because the complete, I would say mostly the antagonist, mostly the person whose interests are completely misaligned with the interest of the creditors is the promoter. Their interests are mostly misaligned. And they being there in the SCC, if I share the valuation reports with SCC or talk about confidential decisions like what assets to sell, etc., at the SCC, that would divulge something which I don't think should be shared with the promoters at all. But however, the regulations are now talking about sharing of valuation report with the SCC, which would mean it would be bared in the SCC meetings as well. In the meetings, the promoters are also present. The next amendment 46, this is actually dealing with corporate liquidation account, which actually means unclaimed money out of liquidation. Not very important, therefore I like to maybe downplay that. Next change is 46A, which is also pertaining to real estate projects, which is also not very significant that I would like to deal with. Maybe we'll proceed further. Now, that other change which is also very important is that normally when we announce an auction sale in liquidation, we normally fix a time. And under the rules given in Schedule 1, the time is now fixed at 90 days. That is, you can go up to 90 days. Payments within 30 days may be made as per the time granted. 30 days to 90 days, it will carry interest at the rate of 12%. Beyond 90 days, there is no power of the liquidator to extend timeline. And therefore, if 90 days the payment has not been done, the auction fails, the money paid so far by the bidder will stand forfeited. This was the provision all the time. Now, in the past, the experience has always been that 89th day or 88th day, the bidder will come and say, oh, I'm having problem, therefore give me 5 days time. See, please understand the creditors are the bankers. Bankers are very practical people. Bankers realize that it might still be so that there are some genuine difficulties and the person is asking for 5 days time, why don't you give 5 days time? But the issue there is that regulations don't allow me to give a time. I can wait. I can 85th day I can start sending reminders that your 90 days is now coming to an end. There is no scope to extend time beyond that. It's not within my control to extend time. Therefore, I cannot. So now the regulations are giving a little bit of flexibility. It's saying with the SCC approval, that timeline may also be. Ashokji, I'll be coming to you a minute from now. The timeline can be extended with the approval of the SCC. Little more changes, which is more like compliance oriented. So I wouldn't be taking your time on that. So the point I was making is that now there is much more increased role, much more increased intervention of the stakeholders consultation committee. Ashokji, you had raised hand, so if you would like to maybe speak, there are some questions on the chat also. I'll be tackling those, but Ashokji, you can maybe unmute yourself and speak. Mr. Ashok Jain.
Yeah, thank you, Kothari sir. Say, I have to know your views on this disclosure of valuation methodology to SEC Regulation 35(5), which is an amendment. Say, what was happening? There were definitely valuation inconsistencies and maybe the approach for a going concern, which can be revived or which can be resolved, and a concern which is not reviewable. So the approach was not very much different earlier. So whether with this 35.5 regulation, according to your view, those inconsistencies, those approach difference, those methodology difference would be minimized?
No, unfortunately, I don't have experience, Ashokji, I don't have experience of SCCs at all, because whatever liquidations
Okay.
I was handling or I am handling, they did not require SCCs. They're old matters. And while we dealt with, we had advisory committees of creditors, but they were not SCCs. These were representatives of the financial creditors, which we retained for the sake of taking the consultations. So while we had creditors committees, but they were not SCCs as per the regulations, right? Now, in this
Okay.
process of consultation with the creditors, I would say discussions were very helpful, because bankers are very practical people. Bankers are extremely practical people. Sometimes we get very practical suggestions from bankers. I'll give an example.
Yeah.
When a particular sale, we were trying to do it time and again, and we were saying we will continue to go on a slum sale basis, and people were not coming. For slum sale, people were not coming. So bankers came with suggestion, why don't you, sir, आप piecemeal try करिए. आप piecemeal और slum sale दोनों साथ try करिए. Because the moment you go for a piecemeal sale, there's somebody who's willing to just buy the land, somebody willing to buy just buy the building. So it might so happen that once the possibility of buying just some assets is seen by people, and those sum of parts is greater than the whole piece also. So even the slum sale bidder will be forced to revise his bid, because then the person see, otherwise the building or land will go away, nothing will be left in the plant. Therefore, I should also revise my bid upwards. So we actually did that, and we were able to see that the slum sale bidder who was not coming forth earlier, the moment we announced for piecemeal sale, the slum sale bidder revises bid upwards, and therefore the sale could happen. So sometimes we get very practical suggestions. Banks have been having experience much longer than any of us, and therefore their experience is quite useful. So while I would say the experience of financial traders is very helpful, but what I'm not clear on, and I think if others have experience with FCCs, they can probably contribute. The moment we got other stakeholders, the moment we got government department, operational traders, workers, employees, etc., their interests are completely divergent. So getting their concurrence becomes very difficult, and the regulations provide a voting share which is based on their admitted claims. So the admitted claims of government, for example, government has taxation dues. In terms of priority, it might be zero. In terms of priority, the government will get zero. But going by the admitted value of claims, the claim could be quite large. And therefore, the government might vote out things which even the secure traders might agree to. So it's this conflict that though the liquidation value of the claim can be very low, but the admitted claim value is very high, which is giving them very high voting share. So the lower classes in the liquidation chain, in the liquidation hierarchy, they may outvote the senior classes. This is exactly the inherent dilemma, the inherent conflict in the process of SCC consultation. I was hoping that somebody could probably share experience. I'd spoken to some liquidators; they also had similar concerns that it's actually a very conflicted body. So Ashokji, if you have experience, you could probably share. I can also see there are some comments on the chat board. I'll be reading those. But Ashokji, if you have something to say.
No, that's what, sir. Actually, Kothari sir, being a banker and participated in many COCs. Of course, now in SCC also, the financial creditor is also there. The basic, and I think I have read in one of your article also, what was happening, particularly this valuation was a very challengeable, or was a very issue which is was a ticklish issue, in the sense that even if there is a going concern, there is a chances of revival or resolution, the approach in the liquidation was not like a enterprise value. They were taking the finally the residual value of the assets, which was defeating the purpose.
Absolutely.
At one side, we want to maximize the value, and the other side, the approach of valuers were that. So that's why what I was thinking, that maybe this 35.5, since he has to put up the details, the method adopted, the approaches, it may help in getting a better valuation. So ultimately, there must be a difference in approach for a concern which can be revived, a concern which cannot be revived. I have seen in practically 800 crores valuation prior to NCLT, admission, and after that the value is just coming down to 100 crores in cases. So how it can happen overnight? Balance sheet is saying good assets value with valuation, but valuation reports were coming like that. So I think so that's why just I wanted to have your view. But this 35.5 may help in that now.
No, completely agree, Ashok.
Because ultimately,
yeah, kindly go ahead.
yes. Thank you.
Yeah, I think the point well made that the approach to valuation, are you valuing assets on piecemeal basis or approaching valuing on enterprise value basis? Fair value versus liquidation value, because typically when you go for liquidation valuations, the valuers value assets on liquidation value basis, whereas fair value approach could be a lot different. So, and you are also right that once we get an asset valued and we have a valuation report, the valuation report becomes the basis for bidders. The bidders know that valuation is 100
Yeah.
crores, they'll start bidding 105 crores. Therefore, there was actually earlier a very good suggestion that we should actually start auctions without disclosing the value. We should ask people to go for a blind auction without disclosing any value at all, because we don't need to say reserve price. The moment you announce a reserve price, the bids start coming starting from the reserve price. And therefore, if I go for an auction without reserve price, that might actually maximize participation, and therefore it might help us to. Reserve price is unconcealed. It's not disclosed, undisclosed reserve price. We have a reserve price, but we don't disclose it with a view to maximize participation. That also might give a good participation. Let me see. There are some comments on the chat board. Mr. Alok Koshik saying liquidator can define the scope of valuation. That's perfectly okay. Mr. Sornakalai is saying, Mr. Selvaraj is saying, sir, I got clarified. RP is going to be member of monitoring committee. If you could move, that's correct. RP can be member of monitoring committee now. You're right. And then there is a comment by Mr. Patnaik saying it was 90 days. Section 12A can be applied. Mr. Patnaik, not sure is referring to what. Probably is talking about the notice, the completion of sale. I think is mentioning about that. Mr. Tandon says might need to more delays. I think the SCC, Mr. Tandon is probably talking about SCCs, that this might result into more delays in liquidation process. Yeah, that's a possibility, because if SCC consists of people with diverse interests, it might delay the process. So these were some of the changes in the liquidation process, and now we'll be discussing the changes in CRP. We'll be coming to some details of each of these. I'm just running through major changes now. Like in case of the stakeholders consultation committee, the meetings are now need to be monthly. Similarly for COCs also, the meetings have to be monthly. The maximum time voting, this is a very interesting change. Voting window is now a little flexible time. Very interesting provision. I would let my colleague Barsha talk about it. Let me just quickly state this and then pass it over to her. The voting timeline. Now, the provision is so very interesting. I just like to maybe put it on the screen and you'll be able to see how interesting the provision is. Just give me a second. Barsha, maybe you can put the change about the timeline for voting on screen, and then we can quickly discuss, and then you can carry it forth.
Right.
Host may allow presentation rights to Barsha. You are having presentation right, are you?
Yeah, she is co-host. She can share her screen. So is it visible now?
Yes, it is. So this is a very interesting change. You can see we're talking about regulation 25. Yeah. So it says seek a vote of the members who did not vote at the COC itself. Seek a vote of the members who did not vote at the meeting on the matters listed for voting. First of all, and once again, the experience mostly is that voting rarely happens at the meeting. At the meeting, most of the COC members say, I'll have to go consult my seniors and come back. I'll vote after consulting, because people who come to COCs mostly are not able to vote then and there. They discuss the matter, absorb the matter, participate in discussion. Mostly say, I'll go back to my office, take concurrence of my seniors, and then only vote. So it says, seek a vote of members who did not vote at the meeting by electronic voting. That would mean you can vote on electronic voting in accordance with Regulation 26, where the voting shall be kept open from the circulation of the minutes. Actually, circulation of proposal. Minutes meaning the minutes actually mean decision already made, but it should actually be circulation of the proposal or circulation of the motion for such time as decided by the committee, which shall not be less than 24 hours, shall not exceed 7 days. That would mean I can keep the voting line open for 7 days. Understand? Not less than 24 hours, you can max keep it open for 7 days. Timeline is decided by the COC itself. Mostly will probably say, okay, decide by 3 days, decide by 4 days, decide by 5 days, but decide quickly because we need to move fast. Now come to provision. Provided that on a request for extension made by a creditor, request for extension made by a creditor, meaning any creditor, the voting window shall be extended. That would mean I cannot decline. On request made by a creditor, the voting window shall be extended in increments of 24 hours period. So I fixed the time. Let's say, see, bankers would normally say, okay, sir, please, the regulation allows me 7 days time, so please give 7 days time. Most of you are bankers here, I guess. Ashok ji is a banker. I saw Mr. Bahati also is a very senior banker. I think there are others also who are bankers. So hope you are not taking an offense if I were to say that mostly bankers will ask for, if regulation gives 7 days time, give us 7 days time. And then at the end of 7 days, you'll probably say, oh, sir, my senior is on leave, he is not being able to decide. So give me 24 hours extra. If you ask for it, regulation says you are bound to give it. This way, 24 hours each time, because there is no limitation. How many extension can you ask for? There is no extension. But provided further, the resolution provision shall not extend voting window where matters listed for voting have already received the requisite majority. That would mean the only point when I stop giving extensions is when I already got the requisite majority. If I got the requisite majority anyways, then what is the point of extension? If the present, see, the voting window is actually, sorry, if the requisite assent has already been obtained, question of extension does not arise at all. However, mostly, once again I would say, mostly if you go for voting through a opaque platform, there is opacity on the platform, even the resolution professional wouldn't know what the votes have been. I'll get to know the votes only when I've opened up the voting line. Then I opened up only when the timeline has elapsed. While the timeline is open, even I shouldn't be able to get the votes. However, it's talking about a sort of unlimited bandwidth, unlimited number of occasions when a single creditor could ask for extension, and the timeline will therefore keep getting extended. This is what will probably now mean more requests for extensions, and therefore the whole matter dragging even beyond the time that is now been dragging. I can see there are several people who have put comments already. If somebody would like to speak, you can definitely speak. Vaishali Agarwal said their monthly meetings requirement is applicable in case resolution plan has already been submitted before AA. There is no exclusion given as such. Then Maya Gupta says monthly meetings should be modified to quarterly. This is, I think, possible because COC may decide to make it quarterly instead of monthly. Manish Bhagati says no time limit for extension. That's perfectly right. Deepa once again says, yes, you're right. This is what we face every time. Mr. Alok Kaushik says 7 days extension taken in bulk. No, it's extension of 24. I can initially fix a time which will within 24 hours to 7 days max. That's initial fixation. Thereafter, in installments of 24 hours each. How many installments of 24 hours I wouldn't know. So that's what is the problem, that every time a creditor could keep asking. It's also not saying that the same creditor who asked for extension earlier cannot be asking for extension once again. If State Bank of India asks for extension once, can SBI not be asking for extension once again? That is also not coming clear. Which means every time I might be getting either the same creditor or a new creditor asking for extension, which can continue to elongate the process. Mr. Himanshu Kapade says time can be extended within 7 days. Okay, Mr. Himanshu's view is that even the extension will have to be within 7 days only. This is a very interesting interpretation. Let's see if it's possible to interpret. that the extension shall also be within 7 days only. I don't seem to think, it doesn't seem to be, because proviso, it says such time as decided which shall not be less than 24 hours, shall not exceed 7 days. But then it goes to the provided on request of extension made by creditor, the voting window shall be extended in increments of 24 hours. Himanshuji is probably taking the interpretation that even the incremented time window has to stop within 7 days. That's a very interesting interpretation, Himanshuji. I would appreciate if that's the view, because looking at the language, it doesn't seem to be worded that way. But I'll be happy if IBA clarifies that their intent was that even the extended timeline has to end within maximum 7 days. That is a very, very interesting interpretation if that is the intent of the draftsman. But unfortunately, it's not coming that way clearly. So with this, Barsha, if you can maybe continue discussion forward.
Right, sir. I hope my screen is visible to all.
Yes.
So I'll start with the amendments made in CIRP regulations. Basically, there are 10 amendments that has been introduced in CIRP regulation. The very first amendment is regarding opening of a separate bank account in case of real estate projects, which is not mentioned here because it was a minor change which has been introduced now. MCA has already introduced a circular, provided a circular wherein it was proposed that project-wise insolvency will be introduced. However, no such changes has been made in court for the time being. In the meantime, in regulation 4D, the regulation 4D is a new insertions made in CIRP regulation that provides that a separate bank accounts will be opened in case of real estate projects. Of course, it is to ease the provide ease in case of real estate projects, given the real estate companies particularly dealing with different projects. It will provide ease to the resolution professional to make subsequent distribution. So this was in regulation 4D. The next change is with respect to holding of COC meeting, which Mr. Kothari has also discussed, that in regulation 18.1, now it has made mandatory to hold monthly meeting of COC. Earlier, it was not monthly, it was restricted. It was mentioned that the COC is required to hold a meeting of COC. The resolution professional is required to hold a meeting of COC as and when he considers necessary. But now it has made mandatory to hold at least one meeting in a quarter, and if COC decides otherwise, at least one meeting every month. So this has, further increased burden on the resolution professional to hold a meeting every month unless otherwise decided by the COC, given that regulation 19 also requires the resolution professional to send 5 days notice. So if by the time the resolution professional is done with one meeting, the resolution professional has to start preparing for the next meeting. So this will certainly increase the burden on resolution professionals to hold meeting of committee of creditors every month. Next change is in regulation 25(5)(b). This regulation is substituted. This regulation has also been dealt with by Mr. Kothari, wherein it was mentioned that the timing, the voting timeline provided to the COC members. So those who are attending the meeting are required to vote at the meeting. If, say, suppose they are not voting at the meeting, so the resolution professional is required to circulate the meeting minutes of the meeting to them and to ask them to vote within a period of 48 hours. This was the earlier regulation. However, now the regulation requires that those who are not voting at the meeting, they are required. The resolution professional is required to circulate the minutes so that they can also vote, and the timeline is also specified, which is 24 hours to 7 days. As somebody has suggested that this particular 7 days timeline is the maximum timeline, even after considering the extension that are required to be provided. But there is no clarification as such for the time being, as the proviso to this particular regulation says that a request for extension made by a creditor, the voting window shall be extended in increment of 24 hours period. So in every request made by the creditor, for the time being, till there is further clarification provided by IBBI, the resolution professional has to extend the voting window by 24 hours. It has also been provided the separate resolution, the subsequent proviso has been introduced, which requires the resolution professional to not extend the voting window where matters listed for voting have already received requisite majority vote and one extension has been given. So say suppose in a matter the requisite majority vote is received and also one extension is granted, then thereafter no further extension is required to be granted. So here one can say that even if say suppose one is receiving the requisite majority vote, then also one extension at least is required to be given and no further extension is required to be given as per the recent amendment which is made in CIRP regulations. Next, coming to regulation 31B. This regulation 31B requires the RP to take approval of COC for every operational cost at every COC meetings. So now that it has made mandatory for the resolution professionals to hold a meeting of creditors at least once in quarter or every month, if not otherwise decided by the COC committee, in that case, the resolution professional is also required to place the operational status of the corporate debtor and is required to seek approval for all the costs incurred by it. So the resolution professional has to be very, very cautious while entering the cost, will have to prepare a details of the operational status of the corporate debtor and has to place the entire record in each of the meeting, which certainly will increase the task of the resolution professional. Those who have some practical experience regarding convening the COC meeting may say that whether these amendments will at all be helpful to them, whether at all these amendments will make any kind of the process more efficient, or this will increase the burden of resolution professional further. Anybody will like to share their views regarding this? There are certain queries mentioned. Ma'am, cases where plan has already been admitted before AA for the approval, in that case also is it mandatory to hold monthly meeting? This Mr. Kothari has already clarified, sir, that so far there is no clarification in this regard as to what will happen in the cases where resolution plan is already approved or an application in this regard has been submitted with the adjudicating authority, whether still the resolution professional is required to hold the meeting. Because we'll see in the subsequent amendments that resolution professional is continued to be the resolution professional unless the approval of resolution plan is received or otherwise decided by the adjudicating authority. So till the time the resolution professional has to act as a resolution professional, and whether at all this will this requirement will continue to the matters where the matter are already at the conclusive stage or have already the resolution plan is already submitted with the adjudicating authority. If at all this requirement will continue or not, I think IBBI will certainly provide some clarification in this regard. Coming to the next amendment, which is 35A1. Here, a proviso has been inserted. This particular regulation was about valuation conducted by registered valuers. So earlier it was provided that RP is required to appoint 2 registered valuers and get the valuation done based on the valuation arrived by the 2 registered valuers. The reserve price of the assets has to be decided, and if there is a deviation, in that case RP may appoint a third or the arbiter valuer as well. However, now it is provided that in case where the RP is appointing 2 registered valuer, and there is a the cases where the registered valuer is appointing in case where the resolution professional is appointing registered valuers, in that case the registered valuers are not only required to prepare the report, the registered valuers are also required to explain the methodology being adopted and arrived at the valuation. to the members of COC. So the registered valuers are also required to be very, very cautious while making the report, as they are required to share the explanation, to provide the explanation and share the methodology based on which the valuation has been derived. So now registered valuers are also answerable to COC, and they are also required to make the presentation before the COC with respect to the methodology adopted at the for arriving the valuation. Coming to the next changes, which is regulation 35(2), this regulation was substituted. This particular regulation, this provides that earlier it was provided that after receiving of resolution plan in accordance with the code and these regulations, the resolution professional shall provide the fair value and liquidation value to every member. So earlier it was required to provide only fair value and liquidation value. Resolution professionals were not required to share the entire valuation report with the COC members. However, now it has been changed. It is now made mandatory for the resolution professionals to share the entire valuation report with the COC members. And of course, after receiving an undertaking from their end, that they will not make any undue gain, any undue advantage based on the information mentioned therein. So now the resolution professionals are required to share entire valuation reports with the COC members. Next is regulation 36(2). Here, regulation KA is inserted. This regulation 36 is about contents of information memorandum, as to what all information should be provided in the information memorandum. Here, it has been mentioned, the necessary amendments which is included is that COC may decide not to disclose the fair value of the asset. If COC thinks that not disclosing the same will make the make it beneficial for the resolution process, so COC may decide not to disclose that particular fair value in the information memorandum, and accordingly, RP is required to place the expression of interest for the assets of the corporate debtor. Next change is regulation 36A. It is clarificatory. It is provided, it is again connected with that real estate project part only. Earlier, I mentioned that now it is provided, regulation 4D is inserted to provide that the resolution professional in case of real estate projects, the corporate debtor which are engaged in real estate business is required to open separate bank account. While there are no particular changes with respect to project-wise insolvencies mentioned in the code for the time being, however, regulation now provides that resolution professional, after the approval of COC, may invite resolution plan for each real estate projects or group of project of the corporate debt. So this is like a separate resolution plan for separate projects. This insertion is made in the regulation. However, no corresponding changes are there in the code for the time being. Coming to the next change, which is regulation 38(3). This change is about appointment of monitoring committee for implementation of resolution plan. I believe that those who have seen the end stage of CIRP, like the cases where resolution plans are approved, are certainly aware that in every approved resolution plan, the monitoring committee, the concept of monitoring committee is mentioned, that who will oversee whether the resolution plan is being implemented or not. So in most of the resolution plan, the concept of monitoring committee is mentioned, who will be responsible to oversee the implementation of the process. Now it is mentioned, now it is incorporated in the regulation as well, that in the resolution plan, while deciding the resolution plan itself, COC has to decide as to who all will be in the monitoring committee, and also whether the RP will continue to act as RP will, whether the RP will continue during the implementation of this resolution plan as a supporter to the monitoring committee, or a separate professional, separate insolvency professional will be there to assess the monitoring committee during that implementation of resolution plan. And of course, the fees of that RP who will be assisting the COs, this monitoring committee during implementation, also has to be decided at the time of approval of resolution plan itself. So this is the change. Next change is again is clarificatory. This is in regulation 40, sub-regulation 2, which is about extension of CIRP period. it is clarificatory. This particular change clarifies that resolution professional shall continue to discharge his responsibility under the CIRP process till the application for extension is decided by the adjudicating authority. As I said earlier, it is now clearly mentioned in the provision itself that RP will act as RP till the time the adjudicating authority decides on the resolution plan. So till the time there is any the adjudicating authority is deciding on the resolution plan, till such time RP will continue to act as RP. These are the changes in CIRP regulations. So before moving ahead towards the voluntary liquidation changes and other amendments, I would request the members, if they have any queries, I'd like to take the queries now. So there's a question. Please clarify whether shareholder will have voting rights in SCC or not. So this is particularly relating to the liquidation regulation. However, I would like to answer this question that in liquidation regulation, it is provided that shareholders will form part of the SCC while they will be in the SCC. However, they don't have any right to vote in the SCC. Is there any further queries? Okay, sure. I'll move ahead with the voluntary liquidation regulations now. In the voluntary liquidation regulations, there are there is one significant change and rest are the clarificatory changes. The first change is about declaration of solvency. So voluntary liquidation is about solvent liquidation. Company which is solvent can opt for this voluntary liquidation process, and therefore the company is required to take declaration from majority of its directors regarding the solvency of the company. This is the prerequisite for opting for the voluntary liquidation process. Now, the what all contents will be there in the declaration of solvency is also provided in the voluntary liquidation regulations as to what all contents should be there in the declaration of solvency to be taken from the respective majority of directors of the corporate person which is undergoing voluntary liquidation process. Therein, one addition has been made in Regulation 3. The addition is with respect to pending proceedings before statutory authorities concerning the corporate data. So now the directors are also required to make disclosure as to what all proceedings are pending before statutory authorities, which all are concerned the corporate data, and also required to mention that they have made sufficient provisions to meet the obligation arising on account of pending matters. So the directors of the company, before deciding that the company should opt for voluntary liquidation process, have to make a clear provision that the statutory obligations which are there on the corporate debtor are sufficiently provided with before opting for this voluntary liquidation process. So this particular part is inserted in the voluntary liquidation regulation, and rest of the things are basically clarificatory only, given that the concept of early dissolution in case there are no creditors is also provided in the voluntary liquidation process. I'll just sum up this part that earlier it was that the voluntary liquidation process has to be closed within a period of 12 months. Now it is provided that in case there are no creditors, there is no reason to get to extend the voluntary liquidation period process for a period of 12 months. Hence, the timeline is made short to 90 days. So when the cases where there are no creditors, the process is required to be concluded within a period of 90 days. Where there are creditors, the process is required to be concluded within a period of 270 days. So the process overall is not even touching the 365 days. However, in the several regulations, there is a concept of annual status report. Given that this annuality is now no more there, hence there are certain changes introduced in the regulation. So now the liquidator is required to share the status report and not annual status report with the contributories if at all the timeline for the process is getting extended. So the changes are introduced in regulation 37(2) in this regard, that reduction of timeline for holding the meeting of contributories if VL process is not concluded within the prescribed timeline. So now they have to hold the meeting within 7 days from the conclusion of the respective timeline. So say suppose when there is a timeline of 90 days, the meeting has to be held within the next 7 days from the conclusion of 90 days. Likewise, when the process is of 270 days, in case of creditors, there the liquidator is required to hold the meeting of contributories and share the annual status report within 7 days after completion of that 270 days. Next is the process with respect to making claim from corporate voluntary liquidation account. So now it is provided that till the time the company is getting dissolved, the liquidator shall be responsible for taking out the money if, say, suppose a creditor comes up after filing the dissolution application, but before the dissolution is approved by the adjudicating authority. So liquidator has to see and scrutinize the claim and accordingly have to make the necessary application to the board to take out the money from that fund. And when dissolution has already approved by the adjudicating authority, in that case, application has to be made to Insolvency and Bankruptcy Board of India and not the liquidator. So these are the changes in the voluntary liquidation process. Now coming to the model bylaws, there's
a hand raise, you can see. There's a hand raise also, plus I think.
Sorry, sir.
There is somebody is raised hand. Mr. Sardindu has raised hand. You can see the hand raised. Ask him to.
So you may please unmute yourself and ask queries, sir.
Yes, sir. I have a question. I am acting as a voluntary liquidator of a company.
Right, sir.
Actually, in case of voluntary liquidation, after completion of all the process, then the application under section 59 subsection 7 is to be submitted. That means till that time, till 270 days or 90 days, the adjudicating authority does not know anything because there is no application with them. Now what happens if I face some problem? For example, I face some problem that some creditors, they file their claim after say 30 days. So after 30 days, the liquidator has no power to entertain that claim. So in that case, there is a conflict. So how to in that case, what I did, I took that matter to the stakeholders consultation committee. I told them, you see, the asset is more than liability, and one genuine creditor, he has a claim. Now he has submitted the claim, but I don't have power to take that to admit that claim. So please give me your consent, so that if all the stakeholders give their consent, I can admit the claim, I can pay them. But the stakeholders consultation committee, those stakeholders, they say, no, we cannot give you any consent, any our opinion. You do what the law said. So in that case, I don't have power. So I filed an application under section 35(1), requesting the adjudicating authority to give me direction in this case. But adjudicating authority says, no CP can be filed in this case because there is no main application under section 59(7) is not pending before us. So how can we take this matter? So please advise me in this case.
So first of all, the concept of forming stakeholder consultation committee is not there in the voluntary liquidation regulation. It requires the liquidator to consult the stakeholders as and when required. And the stakeholders' right is also restrictive, is not like it is advisory as of now. And unlike the liquidation regulation, the changes that have been made in the liquidation regulations, so stakeholders' role in case of voluntary liquidation is still advisory. Now coming to the claim which has been filed by the respective creditor. So the voluntary liquidation is a case of solvent liquidation. Here, the directors of the companies are saying that they have sufficient assets, or the assets of the company are sufficient to meet all the liabilities, irrespective of the fact that the claims are submitted or not. If the claim are not submitted, claim must be there in the books of records of the company. So liquidator should not just limit itself to admit the claim which are filed, but also should admit the claim which are there in the books and records of the corporate
No,
person.
then what is the requirement of inviting the claim? Public announcement, then what is the requirement of public announcement?
Sir, because
if the voluntary liquidator will pay as per the books of account, then what is the requirement of inviting claim through public announcement? And there is 30 days. 30 days time is given. After 30 days, how the liquidator, there is no such provision whether liquidator can entertain the claim or not. That means liquidator has no power at all after 30 days if something is claimed. So in another case, what I did, many creditors they claimed after 30 days, but both the stakeholders means both the shareholders in the meeting, they agreed. So I did not have any problem. Here, one shareholder agrees, other shareholder does not agree. He said, law says this. So if I do something, then I will be in problem. That's why I am seeking the advice of the adjudicating authority. Adjudicating authority says, no, I cannot give you any advice.
Can I interfere? Okay. So sir, first of all, in voluntary liquidation process, the role of the adjudicating authority is only for passing orders for dissolution of the corporate debtor. They don't have any other role at all. The entire process is completely non-adjudicatory except at the time of dissolution. Hence, there is no question of seeking any direction of adjudicating authority at all. That's part one. Part two, the timeline of 30 days is procedural. It is there in every case. In CRP, we fix up a time for filing claim. In liquidation regulations, we fix up a time for filing. I mean, normal liquidation. Insolvent liquidation, we fix up a time for filing claim. In insolvent liquidation, we fix up a time for filing claim 30 days. After 30 days, no claim shall be accepted, right? And claims actually come how long? In reality, have we not seen claims coming after 3 years? We have seen claim coming after 5 years also. Claims are filed after 5 years. They go for NCLT extension of time, the NCLT grants extension. The question is that wherever there is a time limit for filing claims, the timeline is procedural. It's not an absolute timeline that cannot be transgressed at all. So there is absolutely no question. If you've got a claim, you think the claim is genuine, the claim is the claim is verifiable, you can just go ahead and pay for the claim, irrespective of what the contributories say. Because there's nothing in the law which stops you from admitting a claim. If the claim is, and if, on the contrary, if you go ahead and make a distribution to the contributories without paying a genuine claimant, that would actually be a breach of the duties of the liquidator. So in my view, there's nothing wrong in you admitting the claim. If you think there is a genuine reason and the claim is verifiable, that you are not doubting the claim itself is verifiable, the claim itself is genuine, please go ahead and pay it. No issue at all.
Thank you, sir. Thank you.
Harsha, move on.
Is there any other question regarding voluntary liquidation regulations, or should I move ahead with the other amendments?
Yeah, madam, this is Srinivas here. There is one
Yes.
practical problem is happening. There is a foreign company. 2 directors are there in foreign directors, 1 Indian director. So we have passed the board resolution. By the time we got that declaration from that foreign, it is taking 3-4 months, 2-3 months practically. That apostolization and all this thing, the declaration of solvency has to happen. So by the time it came, it is 2 months. And the regulation says within 4 weeks, you have to call for the EGM, right? Shareholders meeting, right? So that practical problem, to resolve it, means we are just taking that regulation that let the one foreign director resign and increase 1 or 2 Indian directors, so that the majority only Indian director will resign and will execute that whatever is the document. Is it our stance good? Because the rule says, it is not saying, regulation says it is majority of the director. It is not saying from India or outside. Let's say 1 foreign director, 2 Indian directors are there. Out of 3, I can take these 2 Indian directors and get it executed, right? All the declaration of solvency, whatever is required.
Sir, what I would suggest, you see,
Yeah,
declaration of solvency is a very serious declaration.
correct.
If declaration of solvency is signed
Hmm.
and eventually the company turns not to be solvent,
Hmm.
what happens?
No, it is a solvent company.
No, I'm saying it is solvent. You're saying that the company is solvent.
Yeah, it's a
As we,
solvent. There is no creditors, only cash balance is there.
no, what I'm saying, think of a normal situation. In this
Yeah,
case, you are aware of the case. I'm not aware. Think of a
correct.
situation where we say the assets are looking good, the
Hmm.
liabilities are limited, therefore we will be able to pay all the liabilities.
Hmm.
As we start disposing of the assets, we find the assets are fetching much lesser than expected,
Hmm.
and therefore we don't have sufficient cash.
Hmm.
The company was into voluntary liquidation, thinking that the company is solvent. What
Correct.
happens in that situation?
Hmm.
Declaration of solvency is very serious and exposes the directors to personal liability
Correct.
if the company turns out to be not solvent. The directors will then be liable to pay for those personally. So it's a very
Correct.
serious obligation. Therefore, expecting new directors who are appointed just recently to
Hmm.
sign while technically it's okay, you get
Yeah.
new directors if they are comfortable, they can sign a declaration of solvency and you can get the confirmation by majority.
Hmm. Hmm.
But in your case, you are able to manage that. But I think in any normal case, directors signing a declaration of solvency will be quite tough, because particularly professional directors, they'll say, why would we expose ourselves to any such liability?
But is the known director, they agreed to sign it because
I'm the agreed to
it's,
sign, no issue.
yeah.
No issue.
No, but the
No issue.
problem is, even if you want to start the process, they are 100% confident that again it will take 2-3 months.
That's
This
okay, sir,
they
because
cannot
you did
satisfy
mention the
the.
difficulty is the time taken in
Yeah.
apostolization. I can see that is the problem. So
Okay.
here you can have a requisite number of Indian directors to constitute a majority, so
Yeah.
that you don't need to wait for the confirmation of
Apostolation.
the foreign
Correct.
director.
So we are thinking that.
I
Thank you.
think you can get that still, though the resolution will proceed, but you
Hmm.
can still get the confirmation from the foreign director also. So he is not out of the obligation.
Correct, sir. But I'm not able to satisfy within that 4 weeks. That is only the
I'm saying
challenge.
you can go ahead with the approval of the majority,
Ah,
but
okay.
don't not take. I mean, that would mean still ask for the confirmation from foreign director also, even if it comes after time. Okay, that will
I have
improve.
a question. Once the resolution, voluntary liquidation resolution is passed, how anybody can appoint the director thereafter?
It is not at. It
I'm
is
saying
not at, sir.
before. He's saying
Before.
before
Okay,
commencement.
okay.
Before.
Resolution of the meeting will be the commencement, no?
Yeah,
Before that, the
yeah.
directors are appointed, and that is a practical solution to the problem that Mr. Srinivas was talking about.
Yes. So because
Okay,
they are
okay.
saying that, even if you try 2-3 times, next to 2-3 times, this is going to be, not solved. And they are shouting at, as you said, 90 days and all. So you are not able to give the practical. Then we thought we can't say loophole, but we are utilizing that, majority Indian directors as long as, they are giving. Thank you. Thank you, Vinod.
Right, sir. Mr. Vaishali, Ma'am Vaishali has put up a question. Mandatory convening meeting to contribute to persons of more than 270 days already passed. Before that, I think that's okay. Every amendment is always prospectively applicable. It cannot be catching you from behind. Our question is, if I've already lapsed 270 days have passed already, how do we convene a meeting at this stage? So this is applicable
as per
prospective.
the provisions which are existing, like within 15 days, the meeting is required to be called of the contributories, and annual status report is required to be placed before the contributories to proceed ahead or to continue further with the voluntary liquidation process. There are no further questions in the chat box as well. So I'll proceed ahead with the next amendment, which is in model bylaws. It is clarificatory amendment provided with respect to AFA validity. So now this bylaws now provides that AFA shall be valid for a period of 1 year. This 1 year will elapse on 30th June or on 31st of December. Now let us take one example. Say suppose if somebody has taken the AFA on 1st of February. In that case, The validity is 1 year. So ideally, this should expire on the 31st of January next year. But it says that if the expiration date is falling within the period of January to June, in that case, it will remain valid till 30th of June. Likewise, if in case the validity of AFA is falling within the period of July to December, in that case, this will last till 31st of December. And there is one more change, which is regarding the insolvency professionals who have attained the age of 70. So there is no more requirement of any extension of AFA. They are required to conclude the process which are there in the hand, and no further assignments basically they will be able to take. Because AFA is particularly for taking the new assignments. So after 70, you'll not be able to take any new assignments and required to conclude the existing assignment, as AFA will not be renewed in those cases. Now, coming to the amendment which are made in bankruptcy process for personal guarantor. This is again, in this particular amendment, it is provided that disqualification of an IP or IPE acting as IRP or liquidator of corporate debtor is removed basically. So in case there is entire IPE involved, in that case, only those directors or those partners who were the signing authorities will be responsible, until unless there are more than one partners therein looking after the several process thereof. So the show cause notice by the insolvency by the IBBI board in this regard will be issued to the particular partners who were holding the who were overseeing the insolvency process of a particular corporate debtor. Likewise, in case of individual insolvency professionals, the notice will be issued to that individual person. And the similar disqualification has been removed for appointment of professionals too. So if they are appointing any professionals, so in that regard, the similar changes are made in Regulation 5.1. There are certain amendments made in insolvency resolution process for personal guarantors. Here, the restriction which was there for appointing the IRP, RP or liquidator who was earlier handling the CIRP or liquidation process, as the case may be of the corporate debtor, can also be appointed as a liquidator or the bankruptcy trustee for the personal guarantor. There was a restriction earlier. This restriction is now removed. So one can say
I ask
that.
a question?
Yes, sir.
I'm
Plus, there are questions
Jayagopal.
on the chat also.
I already put up the question
Right,
in the
right.
chat.
And there's a question by Mr. Anand Shandille also. Here, Mr. Jayagopal, then you can maybe
Yes,
go
sir,
to the
you
next.
will see.
Yes, sir. Jayagopal, sir.
Yes, this regarding AFA age limiting factor, is it at the commencement of 70 years or completion of 70 years?
So wherever there's an age limit, it's on when you turn 70. That would mean completion of 70 years.
Completion of 70 years.
Okay.
70th year, you are still not 70.
Correct. That's completion of 70. Very interesting. Thank you so much for clarifying. Thank you so much. Thank you.
I had one question. I sent on the chat box also. Sorry for interrupting.
And then no problem, sir.
Yes,
I
sir,
think
yes.
we were just anyway going to deal with the problem.
So
Sir, what
in
was the
case
question we
of
can speak on?
voluntary liquidation, sir, if any amount gets credited after closure of all the process, we closed the process, liquidation account was closed, and we submitted the final report for order of dissolution. One fine day, the gentleman came and said that there is one account where the TDS refund has come and the amount is substantial, around 20 lakh or something. So what remedial action in the capacity of liquidator I should take?
This is very common thing, sir. Have you closed the account already or the bank account is still there?
So liquidation account has been closed.
Company liquidation account में पैसा गिरेगा भी नहीं because income tax will give a refund
वो
order.
वाला account close नहीं हुआ HDFC
so
का
this
पहले
deposit in that. This is a very common thing, very common. Because
So he's
most
saying
of this,
that there was some other account wherein the amount has been credited.
so if that's account of the company, get the money there and distribute it to contributors.
Right. So
if I distribute, then my final report will change because I have
You
already
to,
submitted.
I think, make an amendment then.
supplementary affidavit can be made in that regard and make necessary submissions there.
There's no point in losing the money, na? And this is very common. It's very common that income tax refunds come subsequent.
Okay. So I need to distribute among the contributories in the same proportion.
In the same proportion. I'll also share one of our experience on that. The income tax refund, this kind of refunds are very sticky. They take long time.
Yes, yes.
So let's say the refund is due, but the refund is not refund. So itna jaldi aata nahi. It takes long time. So what will I do? Will I keep waiting for the refund to come pointlessly? Let's say my job is done. I've done all the rest, realization, distribution, everything, and I'm just waiting for a refund to happen. How long will we keep waiting? So here, what we suggest is you can do an in specie distribution. You can distribute the claim on the refund to the contributory, and to enable the contributor to claim the refund, the bank account may be retained. Therefore, as and when the refund comes, it may be posted in that account. This is possible only when the contributory is only one or just a limited number of contributors. If contributors are many, this would not be possible.
There are 3-4 contributors only.
So it's possible then to maybe make a distribution in specie. That is, as and when the refund comes, the amount will be distributed in the same proportion.
Just one question here, Vinod.
And just to say that,
this supplementary affidavit has to be filed before the honorable
I
MC.
think yes, because this will amount to an amendment of the affidavit that you filed already. So I suggest a supplementary should be filed. Atulji, you're saying something?
Thank you so much.
Vinodji.
Thank you.
Yeah, Vinodji, my question was, like you said, of course, the liquidation account has to be closed, and suppose the company account has also been closed, and the final report submitted, and even the dissolution order has come, but the refund comes later. Even after that,
this will require revival application. Companies Act has a process of revival. This also very commonly happens. In past, also many cases, companies after dissolution have had to be revived. There is a 20 years time. Within 20 years, you can revive the company. Long time. So if the company has been dissolved, you can still revive. I think Section 252 of the Companies Act permits it. So you can go for a revival application. This would be only if there's a substantial amount. Otherwise, normally people wouldn't afford the cost of revival. But many cases, the amounts are quite substantial. Therefore, you can go for revival application.
Correct.
You know, the same related one, what I'm talking just now, that foreign director and all. So that there is a tedious amount of around 2 lakhs or something that shareholders, foreign shareholders are ready to forego, but they don't want to, keep that account. The moment you process this thing, you close the account and file the dissolution.
That's okay.
But after some time, if you get the TDS amount, what has to be done?
It will remain unclaimed. What else?
No, but whether AA or IBBA will ride on us, because see, the shareholders themselves saying we are not interested, you close it as it is. I want major amount. I'm not bothered about this 1% TDS, whatever.
Can't wait for the process to remain hanging just for a minor refund.
Correct.
And therefore, if the company's account is closed, dissolution order is also passed, thereafter the refund comes, it will remain an unclaimed amount. And it will eventually.
There is no account also, because we will be closing all the accounts.
Unclaimed, it will remain unclaimed. And therefore that would eventually go back to the government. Any unclaimed monies go to the government basically.
Correct. So is it required to be mentioned in the dissolution application to safeguard the interest of liquidator, so that
I think you can mention that based on the confirmation by the contributors.
Okay.
The account is closed, even though some refund is expected. As and when the refund comes, it may be credited to what you call any benami money goes to the government. That's the principle.
Okay.
Unclaimed money eventually belong to the state.
Better to mention, right? Because
I suggest better. Okay. Though a small thing, but somewhere mentioned. Don't bring it to the notice of highlight. Don't highlight, because NCLTs will be then confused.
Correct.
But just mention it somewhere, just to bury it in the text.
Thank you.
Sir, 1 point, please, sir. Sir,
yes.
1 point, please.
Yes,
sir. Sir, actually, I distributed the amount by making drafts to the shareholders after completion of the process. There were some nominee shareholders. Nominee shareholders that I paid 4,000 or 5,000 rupees per head that I paid. So out of 5 nominee shareholders, 2 nominee shareholders, that means that draft of 4,000 something, those 2 nominee shareholders are not traceable at all. And these 2 drafts are with me. I have already filed the application under Section 59(7). So when these shareholders are not traceable, so what to do?
There's a process now, unclaimed amount to be paid to, there is an account to be, Varsha, you are
There's
a very
corporate voluntary liquidation account, sir, which I have just mentioned. This corporate voluntary liquidation account, you are required to deposit that money therein, and this account will be handled by IBBI. So there could be two situations, like say suppose before the dissolution order is passed by adjudicating authority, say suppose somebody is coming and claiming the amount, in that case liquidator is required to scrutinize the claim and then make payment from that corporate liquidation account. Otherwise, after dissolution, if somebody is coming, in that case, IBBI, the application has to be made to IBBI and respective actions will be taken by IBBI.
Okay, thank you, thank you.
There is a question in the chat box. Can a voluntary liquidation application be withdrawn? If yes, at what stage and under which regulation? So this voluntary liquidation regulation was, I believe that this voluntary liquidation application is required to be filed at the end of the process, like the moment that you are done with the process. Application. This application is basically dissolution application. You are not required to file any voluntary liquidation application per se. But the process, the voluntary liquidation process, once you have started, the process is started with the consent of contributories and accordingly can be ended with the consent of contributories only. Coming to the next changes, basically these are IBBI circulars. There are three circulars issued by IBBI. One was on 1st Feb and two were on 13th of February. So the 1st Feb circular was with respect to the measures for rationalization of regulatory framework for IPEs. Again, this was connected to the earlier amendment which are made. So this particular circular provides that in case assignment is undertaken by IP, in that case, the IP will be responsible for the show cause notice or to answer the show cause notice, and accordingly, the show cause notice issued by the IBBI will be issued upon that individual IP. However, in case of IPE, the partner or the director, as the case may be, who is the IP and who was authorized by the IPE to handle the assignment, the show cause notice will be issued to that particular director or partner. If IPE is of the opinion of, if the board is of the opinion that IPE should be issued the show cause notice, so that circumstances may also arise in case where there are repeated instances on the contravention of provisions, or there are more than one partner or director of the IP involved in the process. Now, coming to the next clarification, which was provided in this circular, was restriction on the number of assignments that IPE can take. So there are no restrictions on the number of assignments that an IPE can take. Next is Regulation 34B of CIRP regulation, which stipulates the minimum fixed fee structure. So this minimum fixed fee structure was provided in CIRP regulation. The circular says that this minimum fixed fee structure and the performance linked incentive for IP shall not apply in case of IPE. Coming to the next circular, which was circular dated 13th of February. So this was regarding the FSP, the voluntary liquidation process in case of financial services provider. Here it is said that the mandatory requirement is to take approval of the regulatory authority as well before initiating the voluntary liquidation process of financial service provider. Given that it was seen in many cases that voluntary liquidation process for a financial service provider was initiated without taking approval of the ultimate regulatory authority, which is RBI. Hence, the clarification was inserted, and there was a format provided for making application for release of fund from the corporate voluntary liquidation account. Corresponding changes are also introduced in the voluntary liquidation regulation, which is already there as to how the amount will be withdrawn from the corporate voluntary liquidation account. So this is all about the changes that are the amendment which are introduced, and there's clarifications which are provided in the circular. If at all anybody has any question in this regard, may please ask. There are no questions in the chat box. So with this, we can end the session today. Thank you everyone for the patience listening and for active participation. Thank you so much.
Thank you very much, ma'am. Thank you very much, sir, for sharing your views and thoughts regarding the recent amendments in IBC regulations and making the session interactive and knowledgeable. Ma'am, you are requested to please kindly share the PPTs with us.
Yes, ma'am. We'll share the PPT. Thank you, everyone.
Thank you. Thank you very much.